The Ninth Amendment to the United States Constitution is one of the most mysterious and often overlooked provisions in the Bill of Rights. Ratified on December 15, 1791, it serves as a safeguard against the assumption that rights not specifically mentioned in the Constitution do not exist. The amendment states, "The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people." This simple yet profound statement was added to address a fundamental concern raised by the Anti-Federalists during the ratification debates. Many feared that by listing specific rights in the Bill of Rights, it could be interpreted that those were the only rights people had, leaving unmentioned rights vulnerable to government encroachment. James Madison, the primary architect of the Bill of Rights, included the Ninth Amendment to make it clear that the people retained other rights beyond those explicitly stated. At its core, the Ninth Amendment was designed to reinforce the principle of natural rights, the belief that individuals possess inherent freedoms that exist independently of government recognition. This concept was heavily influenced by Enlightenment philosophy, particularly the works of John Locke, who argued that governments are created to protect pre-existing rights rather than grant them. The amendment thus acts as a barrier against an overly restrictive interpretation of the Constitution. Despite its importance, the Ninth Amendment was largely ignored by the courts for much of American history. Unlike other provisions of the Bill of Rights, it was rarely invoked in major Supreme Court decisions during the 19th and early 20th centuries. Judges often struggled with how to apply it, as it does not specify what these unenumerated rights actually are. Some feared that relying on it too heavily would grant the judiciary too much power to invent rights that were not explicitly written into the Constitution. However, the amendment gained newfound relevance in the mid-20th century, particularly during the expansion of civil liberties and privacy rights. One of the most significant cases invoking the Ninth Amendment was Griswold v. Connecticut, 1965. In this case, the Supreme Court struck down a law banning contraception for married couples, ruling that such a ban violated the right to privacy, a right not explicitly listed in the Constitution, but inferred from the penumbras of several amendments, including the Ninth. Justice Arthur Goldberg cited the Ninth Amendment in his concurring opinion, arguing that just because a right is not listed does not mean it does not exist. This decision laid the groundwork for future rulings that expanded individual rights, most notably Roe v. Wade, 1973, which recognized a woman's right to choose an abortion as part of her broader right to privacy. The Ninth Amendment was frequently cited in debates over whether rights such as bodily autonomy, personal relationships, and even digital privacy should be constitutionally protected, despite not being explicitly mentioned. The originalist and textualist schools of legal thought, championed by figures like Justice Antonin Scalia, have often downplayed the Ninth Amendment, arguing that its vague nature makes it difficult to apply in a legal setting. Others, however, believe that it is an essential component of constitutional interpretation, ensuring that fundamental rights are not at risk simply because they were not listed in 1787. In modern debates, the Ninth Amendment continues to be cited in discussions about LGBTQ+ rights, healthcare access, digital privacy, and personal autonomy. It remains a powerful yet enigmatic provision, reminding both citizens and lawmakers that the Constitution is not an exhaustive list of our freedoms. While courts have been cautious in their application of the amendment, its presence serves as a lasting acknowledgement that rights exist beyond those explicitly written down, and that the people, not the government, ultimately retain them.